Brooke Friedel.
Brandon Riley on behalf of Ms. Friedel.
Julie Kahn for the Office of the Attorney General.
Okay, and are you ready to proceed today?
Yes, Judge, we have a partial agreement, and the only issue left is retroactive child support.
Okay.
And if I may, I can read the agreement into the record.
You may.
And child support will be $554 per month starting December 1st. Medical support will be $75 per month. And joint managing conservators, mom determines the primary residence in Montgomery or contiguous. And will be a step-up visitation schedule. The first will be supervised, first, third, and fifth Saturdays, or the first, third, and fifth, I guess the Saturday following the first, third, and fifth Friday, from 9 to 11 for 10 times to be supervised by Elaine, I guess the paternal grandfather's girlfriend, or the maternal grandfather's girlfriend. And then the step-up will be the first, third, and fifth Thursdays from 1 to 3, 10 times to be picked up and dropped off at daycare. And then first, third, and fifth Thursdays from 8 to 5 for 10 times. Then Saturday at 6 to Sunday at 6 for 10 times. And then a standard possession order. And at this time, I would call Mr. Lara. Mr. Lara, can you state your name?
Roberto Lara.
And you are the father of
Aviana May. Yeah. Yes.
And you did the DNA testing?
Yes. Yes.
And so if I may share the screen to show State's Exhibit 1, the DNA test report showing that Mr.
Buckle up, guys. Today we're stepping into a hearing that starts quietly, but carries the unmistakable tension of two parents bracing for impact. The attorneys waste no time laying out what's already been settled and what still hangs unresolved. The judge listens closely as the partial agreement is read into the record. Child support, medical contributions, custody structure, and a careful step-up visitation plan designed to stabilize a fragile situation. Everything feels precise, procedural, but the room has that charged stillness that signals more conflict is waiting behind the calm. As the DNA results come in confirming paternity, the stakes lock into place, and you can sense everyone preparing for the real debate to begin.
Lara has not been excluded as the father.
You may do so. Does anyone have any objection to me admitting the DNA test results into evidence?
No objection, Your Honor.
Okay. It's admitted as State's Exhibit 1, and you can share your screen.
Not sure how well that shows up.
It could be bigger.
Make it bigger.
It's legible.
Okay. All right. So it does show that he is the father. All right. And so, Mr. Lara, did you hear the agreement that I just read into the record?
Yes.
And is that your agreement and what you want the court to do today?
That's okay. Yes.
And when did you and Miss Friedel separate?
July.
So it's July of
This year, yeah.
And when you separated, did you give her any money or cash after that to help take care of the child?
I gave her a car and some cash, yes. And well, not that day, but before she actually left, yes, I gave her a truck that I replaced for her car that it was falling apart.
Okay. And so
from this point forward, the tone shifts as the father takes the stand, answering rapid-fire questions about the separation and what financial support he claims he provided. He explains the car he gave the mother, emphasizing the repairs, the value, and the timing, all to show he wasn't absent or indifferent. The judge listens, measuring every detail, especially the sequence of when the vehicle was given and when the title was transferred. You can feel the father trying to frame the car as substantial support, something meaningful enough to offset retroactive child support. It becomes clear that this vehicle isn't just transportation. It's about credibility, responsibility, and the narrative each side is trying to lock into the record.
What kind of car was this?
I gave her a 2009 Honda Pilot SUV. I replaced almost all the parts on the car, and tires and brakes, and I did everything on that car to actually make it very safe for the child.
And did you give this to her after you separated?
I gave it to her the last period whenever she was here, because it was during the summer and she didn't have AC on her car. And you know, the summer with the baby in the car without AC, and the car wasn't working well. So I did it during that period that she was, yes. Not after, during the last month, actually.
And so did you sign the title over to her name?
No, I signed the title after that because it took me a little bit longer to transfer the title. The title I transferred after that, yes, after she left.
Okay. So you'd given her
about
the car while y'all were still together, but after she left, you managed to transfer the title into her name.
Yeah, I transferred the title actually in August because I had to get back the plates of the car. When I bought the car, I had to return the plates to the previous owner. So I had to give back the plates, but it was a very long time since she didn't have a chance to give me the plates back so I can transfer the title to her. So I did that after, I think it was middle of August, part of September, when I get the titles transferred, yes, to her name.
So
Now the numbers hit the table. The judge calculates retroactive support at $2,770, and suddenly the car's value becomes the center of gravity. The father argues confidently, estimating it at more than enough to cover the amount. He describes the condition, the repairs, even the attempted resale price, painting it as an asset worth far more than the support owed. His tone is steady, almost strategic, trying to shift the courtroom's focus to the generosity he believes he's already shown. But behind that presentation is the underlying question the judge must sort out. Was the car a gift, a necessity, or legitimate support? That uncertainty hangs in the air, setting up the clash that's about to follow.
so when I calculate child support, 5 months at $554, I get $2,770. How much do you think that this Honda Pilot is worth?
What was that number? I'm sorry, 2000 what? 7?
$770.
Okay.
And
Yeah.
how much do you think the Honda Pilot is worth?
Well, the car is outside on the market around probably $4,000 to $5,000, even in very good shape, about $6,000-7,000. But this one is in a good shape, not perfect, but it's in a good shape. When I give it to her with brand new tires, brand new brakes, everything, it's around probably 42 to 45. Actually, we put it for sale. She put it for sale in about 46,000. 4,500, 4,600. We put it for sale to get a better car, actually.
And do you think you should get credit for the back child support for giving her this vehicle?
Yeah, I would like to have some credit on that, please.
And did you pay for the vehicle?
Yes, I pay for the vehicle.
I pass the witness, Your Honor.
Mr. Raleigh, do you have questions for Mr. Lara?
No, Your Honor, not at this time.
Okay. You may call your next witness then, Ms. Khan.
I'll call Ms. Friedel. Ms. Friedel, did you hear the agreement that I read into the record?
Yes.
And is that your agreement and what you're asking the court to do today?
I will say, though, I went to Christian Brothers Automotive because they give single moms free oil change. And they were able to take care of my car, but it was over $3,000 that needed to be fixed. And I still have the invoice for that. So, it was really in bad condition whenever I did get the car. There was a lot that needed to be fixed on it that I just didn't have the money to fix it, but
Okay. Objection non-responsive. So we'll get to all of that.
When the mother takes the stand, the room's energy tightens again. She confirms the agreement on visitation and child support, but quickly pivots to her own account of the car, insisting it came with major problems and steep repair costs she couldn't afford. Her attorney keeps pulling her back to the judge's questions, trying to keep the testimony focused, but the emotions are right beneath the surface. The mother pushes the narrative that the car wasn't meaningful support at all, and that she's carried the weight of everything since the separation. Then comes the twist. She briefly agrees to credit the father for the vehicle, only to reverse that position moments later. The judge's expression says everything. This issue isn't simple, and the inconsistency only raises the stakes.
My question was, did you hear the agreement that I read into the record about the child support and the visitation schedule? And is that your agreement and what you're asking
Yes.
for to do
Yes,
today?
ma'am. I agree.
Okay, and then moving on to the car, did y'all split up around July of 2025?
Yes, that's correct.
Okay, and so when I calculate out child support, retroactive child support, I get $2,770. Are you asking for that amount to be put to retroactive or back child support?
Back child support.
And has he given you any cash or money since you separated?
No.
Did he give you the vehicle after you separated?
Yes.
So you're saying he bought the Honda Pilot, he paid for it, and then he gave it to you after y'all were separated.
Yes.
But you don't think he should get credit for that for the back child support?
Yes, that's fine.
Oh, you do want to give him credit for it now?
Yeah.
Okay. So I guess we have a full agreement.
Yeah.
So
Mr. Riley, do you have any questions for her in light of that?
Brooke, has he given you any support related to medical bills for the child since her birth?
No.
Okay. And have you presented those bills to him?
No.
And do you know what amount those bills are at this time?
No.
Okay. As it relates to the vehicle, was the vehicle given to you as part of the relationship?
Questions sharpen as the dialogue digs deeper into what happened after the separation. The mother insists she received no money, no medical help, and no meaningful support outside the vehicle, and her attorney pushes that point with precision. But her shifting stance about whether the car should count becomes the courtroom's quiet pressure point, revealing uncertainty that both attorneys immediately recognize. Details about title transfers, her father's involvement, and the vehicle's condition paint a complicated picture. The judge listens without interruption, weighing whether the car was a necessity the father provided or simply a shared asset handed over after they split. Every line of testimony adds another layer to a ruling that clearly won't be straightforward.
We shared the vehicle in the relationship. He bought the vehicle and he was mainly using the vehicle.
And did he get a new vehicle, or what transpired that it became your primary vehicle?
I believe he did get a new vehicle. He got a white van. Yeah.
Was there any type, what if any type of agreement was laid out related to you receiving the vehicle?
So whenever I moved out, he did let me take the car. And my dad actually met with him to transfer the title. Roberto went to transfer the title to my name, and my dad got the paperwork information for the vehicle.
Did you ask for any support or otherwise during that time period when you separated?
No.
Okay. And you stated earlier that you would ask the judge to give you back child support and to not count the vehicle towards that back child support, correct?
Correct.
And then you changed thereafter. Is that correct as well?
Yes.
Okay, but as of right now, are you asking the court to award you back child support for those months since you've separated?
Yes.
Okay, no further questions, Your Honor.
Ms. Khan, do you have any further questions in light of that?
Just to clarify, I've heard two different things. So at some point you said zero retro, but now are you saying now that you want the 2,770 to be a judgment and to be paid back for that?
Yes, ma'am.
Okay, so you don't want to give him credit for the vehicle?
No.
Okay. All right. I pass the witness, Your Honor.
Mr. Lara, do you have any questions for Ms. Friedel?
Well, the only questions that I have is, in that case, particular case, yes.
The final dispute takes shape when the father requests the child carry his last name. It's a moment that pulls the case out of logistics and into identity and connection. The mother pushes back instantly, arguing that she has been the constant caregiver and that his inconsistent presence doesn't justify a name change. The father fires back, saying he has messages proving he tried to see his daughter and was denied access. Even without seeing the messages, you can feel the emotional stakes rising. This argument isn't about documents or dates. It's about acknowledgement, legacy, and who has truly been present. The judge pauses, taking in both sides, and it's clear the final decision will carry weight beyond this hearing room.